We're going to discuss now the case, a very interesting case that has created a lot of, generated a lot of international interest. A case that the German Bundeskartellamt, the cartel authority, anti-cartel authority, has brought against Facebook. And only recently, the 27th of August, has the top court in Germany, the German Federal Supreme Court, published the reasoning. So this is fairly recent. And we have with us an expert, a German expert on competition law, Professor Rupprecht Podszun from the University of Düsseldorf, who's also the vice president of Ascola and also the editor of a really interesting blog called Descartes that if you don't know, you should, because it makes European and German competition law issues, it brings them to the general public in a wonderful way. So Rupprecht, we are so happy to have you here with us today. Thank you so much. Thank you. It would be great if, you know, let's, if we can talk a bit about the case. So first of all, what's the factual scenario? What started this in the first place?
Thank you, Michal, Madam President, for me, since you're the president of Ascola, just mentioned. Thank you for this invitation. It's a great pleasure and honor to be with you and to discuss this really intriguing case. I asked the presiding judge of that court of the that you've just mentioned the other day what he thinks of the case, and he said it is the most significant decision the Cartel Senate has ever taken. So this is really a case that triggered, as you said, a lot of interest on a global scale even, but also of course in Germany. And it's all started back in 2016 when the Bundeskartellamt, the German National Competition Authority, went into this case. And you have to know that Germany has a tradition sort of some peculiar features of competition law. Maybe we can look into that later, but also the Bundeskartellamt has a tradition of discussing digital cases. So they were early on in all these digital matters. And then they decided, okay, we look into Facebook and we look into what really is at the heart of what Facebook does, namely data. And what they said, the Bundeskartellamt's people said, was that Facebook was abusing its dominant position as a social network by collecting and combining data from different sources. So what they said, or what they found, was Facebook collects our data. We all know that. If you use Facebook as a social network, they get our data in exchange. Sure. But what some people don't know is that Facebook uses these data and combines them with data they collect elsewhere. And they collect data elsewhere on WhatsApp, which belongs to Facebook as well, and Instagram, which belongs to Facebook as well. But they also collect data on all sort of third-party websites. So if you surf the internet, you leave your footprints everywhere and you leave your data everywhere, the sites you visit, etc. And wherever Facebook has access to these data, and they often have these access through plugins, etc., they collect all these data and they combine all these data to what we call super profiles. So Facebook has a super profile of you with all sorts of data.
So when we do the like button, when we push the like button, that provides information, right? Every time we do it, not only on Facebook.
This is enormous. I mean, it's an enormous sort of resource that they have, and they combine all these data. And what the Bundeskartellamt says is you combine these data without proper consent of the user. And this would, if that's true, this amounts to a violation of privacy rules, the General Data Protection Regulation, which is the leading data protection law in the European Union. And so this is sort of the basic scenario, combining user data from all sorts of different sources, not just Facebook in the sense of the social network Facebook, integrating all these data without the consent of users.
Didn't Facebook, when it bought WhatsApp, didn't it promise not to combine the data?
That's what they said in the merger proceedings with the European Commission. And the European Commission bought that. They said it's technically impossible to combine these data. This turned out to be simply false. And actually, Facebook got a fine for making a misstatement in merger proceedings 2 years later. But the European Commission didn't unbundle that merger or didn't go against that. And actually, today, technical experts say that it's very, very difficult. That would really be incredibly hard for Facebook to sort of unbundle and to see, okay, these data are from that source or that source, because the technical layers are so integrated that you cannot simply do that.
Right, right. I can definitely see it. So this was an abuse case, right? Why were people surprised?
People were surprised because what we find, first of all, is a violation of data protection rules, or this is what the Bundeskartellamt bases its case on. Now, we probably agree that not every abuse, not every violation of whatever rules amounts to a competition law violation.
Right.
I mean, it's sort of a bit difficult to, or there may be a case for that, because say if you violate tax laws, you have a competitive advantage over your competitors. So there may be a competitive angle to that. But even for dominant companies, and this is always the threshold that we need to pass if we want to do an abuse case, even for dominant companies, we say that a violation, a breach of other rules does not always amount to an abuse of dominance or a breach of competition law. So many people looked at the case and said, okay, even if it's true that Facebook violates the GDPR, why should that be a matter for competition law? What's the reasoning behind that?
Right,
because
a good question. So what did the court say?
let me just give you the idea that the Bundeskartellamt put forward, because that's interesting too. And the Bundeskartellamt said, we have a provision on exploitation. We don't often use that, exploitative abuses. We don't often go for exploitation of customers.
Right.
But we know these cases, and it is sort of somehow established in legal tradition that you can have cases like excessive pricing. So you sell a good for an excessive price. So that may be an exploitation if you're dominant of your customer base. Sure. Now they say, if you exploit data in an excessive way, that is basically the same thing. It's an exploitation of customers. Right. And the problem is, okay, wait, what is excessive? What is an excessive price? What is an excessive exploitation of data? You have to set a benchmark for that, which is incredibly difficult. What is the right price for anything? And they said, okay, it's excessive if you violate the law. That was the Bundeskartellamt's core reasoning. They put forward a couple of other arguments as well, but this was basically their core reasoning. And now the case went, as you said, the case went to courts in interim proceedings, we have to say. So this is not yet the end of the story. It's still ongoing. But in interim proceedings, the top court in Germany, the Federal Supreme Court, sort of looked into the case again and said, yes, we agree with this argument, but we go even further, or they added a substantial part to this and sort of went a bit away from all this talking about violation of privacy rules. So the top court, some people say they really gave a completely other reasoning than the Bundeskartellamt. But what they said was, A, you have the problem with the customers. You don't give them a choice, and choice is important for competition to work. So customers need to have a choice. Right. And if you don't give them this choice, you also produce a problem for competition, because all this gathering and integrating of data means that the market entry barriers to this market are raised. Other networks cannot go into the market anymore because they simply don't have enough data. And you also create a problem on that other market side of Facebook, namely online advertisements. Right. If you have an enormous amount of data, it's much more difficult for others to get into that advertising market. And they essentially said, customers get something from you that they don't want. You impose on them an obligation to take a personalized user experience for the price of giving away all your data and integrating all your data. And this is something that you as a customer, as a consumer, should have a choice about. Right,
right. But wouldn't the same argument be with regard to the data that Facebook captures on its own, on the use of its own pages?
Well, if you're on the social network, so the court says on Facebook itself, that's fine. If they use the Facebook data, you as a user consent to the use of these data, and the social network exchanges with your friends, the photos you upload, etc. This is sort of all part of the Facebook thing. But integrating other sources, WhatsApp, Instagram, third-party websites, is not sort of included in your personal user experience that you wish to see from that social network. Or you should have a real proper choice. If you agree and say, okay, give me the full power of data use, here are all my data from all sorts of websites, please give me the best personalized experience that I can have, that's fine. But if you don't agree with that, and at present this is sort of the submission, there is no proper consent to that.
Right.
If you don't agree with that, you get something that you don't want. And this is actually something that we often deal with in competition matters, bundling of products. You get more than you want, which may be fine if you look at it at first, but of course you pay for that with some sort of currency.
Sure, and this is also a matter of choice, right? Consumer choice. You can link it. This is if you want a case of excessive data collection, right? Instead of excessive pricing, it's excessive data collection, which harms the choices of consumers because of the dominant position of Facebook.
Yes, and this is something that I find really stunning and interesting about the ruling of that court, because they place so much weight on consumer choice, which in my humble opinion has not yet been the case before in many competition cases. I mean, we discuss consumer welfare all the time and in a very economic sense, but consumer welfare in our reading usually means we need sort of some efficiencies, and the product in the end is 2 cents cheaper than before or so, but we do not really look into the aspect of choice. The concept has been around. There have people around writing about that. Paul Nihoul and Everett and Landy are the ones to be named here probably before. But this is a decision where the court really says, or this is my reading of the decision, the consumer has a say in markets, and the consumer ultimately has to decide. And in competition law, we have to enable the user to take a range of options, because competition depends on this range of options and choice. And that's something that I find very important. And at the same time, the court does not stop there, but it also sees very clearly that this is a multi-sided market, and that the behavior on one market also has repercussions on the other markets. And this is something that I like about the decision as well. It's not just looking at consumer choice, but it also says if you reduce consumer choice there, it means that you're even stronger on the online advertising market. So on the flip side of the market of this platform, and your
network effects.
Yeah, exactly.
Yeah. And there's also the court connects it. You mentioned it before, but if you can say a bit more about the constitutional aspect of the court of the decision.
That's something that has stunned readers as well. This is probably a very German concept as well. So what the court says is that Facebook is dominant. Okay, we probably agree on that somehow, that Facebook is in a dominant position. But the court goes even a step further and says Facebook is so important as a communication platform, as an infrastructure provider for communicating in a digital world, that it is bound to the fundamental rights of the Constitution. And it has to provide all the fundamental rights, or it has to take care that the fundamental rights of the Constitution are respected. And this is stunning for the following reason. Fundamental rights under the German Constitution usually bind the state. So if you're a state authority, if you're a court, if you're a government or something, you have to take care that the people have free speech, that the people may do this and that. Yeah, they are bound by the civil liberties. Now the court says this also applies to a company like Facebook, because they're so powerful and important, and they're so important for communication, which is at the heart of our democracy and everything, that they have to take care. And the right that they invoke is the right to self-determination regarding your personal information. So they say, there's a quote in that judgment saying, as a consumer, as a human being, as someone who has the right to self-determination, you need to have a substantial say of what happens with your data. And Facebook doesn't give this to you, and therefore this is abusive.
Right. This is really, really interesting. So what are the next stages here? What's going to happen now?
Yeah, as we discussed earlier, this is only in interim proceedings, so the main proceedings are still coming, and the case now sort of restarts, if you wish so, at the lower court, which is the Düsseldorf higher regional court that looks into the Bundeskartellamt's decision now again on main proceedings. So they have to judge again. Actually, this Düsseldorf court had been in the interim proceedings as well, and had been very, very critical of the Bundeskartellamt's decision, and had said this is all not feasible the way you do it. So we are now all expecting a very interesting decision in the sense of, okay, how do they deal with that the top court said, no, this is okay, while they themselves had been of the exactly opposite decisions, opinion. So they need to revoke or need to reverse their judgment. I could well imagine that the case takes a bit longer, because there's always the option to send such a case to the European Court of Justice in Luxembourg, which is the EU court. Sure. And as a German court, you may do so, or even may be required to do so, if there is an open question of European law. And there may be one or two, while the case is based on German law, basically, you may also see some EU angle to it, and maybe send it away. Mm-hmm. Having said that, the Bundeskartellamt now at the moment has the power to implement the decision, and it granted Facebook, I think, 12 months after the decision, plus an additional 2 months for whatever reasons. So Facebook now is in a phase where they have to come up with a plan how they implement these changes. Right. And so at present, we see, on the one hand, the proceedings going on in Düsseldorf now, and then maybe going to Luxembourg or going again to the Federal Supreme Court. And at the same time, the implementation proceedings are going on. So that's a very difficult case for Facebook to choose how to deal with the whole matter, because what makes this case really good and interesting is that it aims at the heart of what Facebook is doing. And we've discussed remedies. I mean, Michal, you are on that topic as well, remedies in digital cases. And I think this is a case where if you force Facebook to either grant real proper consent, a real proper choice to users, or say you unbundle your data, this is really a tough cookie for Facebook.
Yeah, it will definitely be a tough cookie, I'm sure. One last question, dominance. There have been people who have talked about markets for attention, and they said that all these firms compete in the same sphere. They all want our eyeballs, right? So if you define the market as market for attention, then Facebook is actually not dominant. How did the court deal with that?
Well, the court has no doubt whatsoever that Facebook is a dominant company in the field of social networks. And specifically regarding attention markets, they say this is not our way to look at market definition. What they say market definition is about is to look from the consumer perspective, from a demand side perspective. So if you are the customer, it's what you sort of see as interchangeable, as substitutes, and the user doesn't say, oh, I take my attention here or there. This is completely not in the concept of demand side substitutability, but the user says, okay, I want to have a social network. And in the market for social networks, so the court says, Facebook is the number one with wide margins. Right.
Well, this is so fascinating, and I'm sure we're in for the ride. I mean, as you said, it hasn't come to its end. But it's a really fascinating issue which combines, as you said, competition law and privacy and the GDPR, and also from a German point of view, constitutional rights. So it's at least very interesting. And thank you so much for doing such a great job of making this understandable for us. Thank you so much.
Thank you, Michal, and all the best to you and your students. Thanks.